Okay, I think to be mindful of everyone's time, we will go ahead and get started. And Marissa's trying to give Pete a hand, and hopefully us here shortly. But thank you for joining us here. This panel is called How to Win an Appeal to the PAC, which these folks here know a thing or two about. We're going to start out with some introductions, and feel free to use the Q&A feature throughout. We will hopefully get to your questions throughout, or we have some time at the end as well. But my name is Courtney Kippers. I'm an independent journalist here in Chicago. Last year, I did a series for the Tribune on all things FOIA in Illinois, including appeals at the PAC's office. I'm excited to be the moderator here and to hear from our all-star panelists. And so let's see, I think we have Pete here. Hopefully he can join us. I just added him. But hey, Pete.
Hello.
Just in time. So we're going to start with some introductions. If you can just briefly introduce yourself, and then maybe real quick, your FOIA origin story, what initially got you into filing FOIAs. Maybe Ryan, if we want to start with you.
Well, so I'm a sports writer with the Springfield newspaper, the State Journal Register. Been full-time since 2011. And fortunately in sports, I don't have to do too many FOIAs. Occasionally I've had to FOIA a school board, usually revolving some kind of coaching decision or, finances, depending on, where they want to build do turf into a stadium or whatnot. So I generally don't have to do a lot. And I happened to go down to a Hillsborough school board meeting last summer in June, and they took all the public comment cards and they called them in one by one into a closed session. And look, I don't do a whole lot of school board meetings unless a coach gets fired, but I kind of knew right away this doesn't seem right. So I asked around to some colleagues of mine who have had a lot more experience covering school boards, and one of my fellow reporters, his exact quote was something like, "That is your story." And I thought, well, my story is the coach getting fired. But so I filed a complaint with the wrong office, actually, with the Illinois Attorney General's office, because I didn't know what I was doing. But and even in their binding decision, they'd even mentioned, even though I didn't submit it to the correct office, it was clearly a request for review. And so that's where it all started.
Okay, we're going to hear a lot more about that in a second. I'll throw it to you, Greg, for a quick intro from you.
Well, I'm Greg Pratt. I cover Mayor Lightfoot for the Chicago Tribune. I've always been a FOIA freak. I remember in college discovering that, if it exists on a piece of paper and the government has it, you have the right to ask for it, and you're probably going to get it. It's not that simple and it's not that easy, but that is the basic truth that I pursue records with, and it is mostly correct.
All right, Pete, over to you. How did you start filing FOIAs?
I retired and I had to find something to do. So I live in the 45th Ward in Chicago, Copland, as it is known. And we have elected the worst of the 49 aldermen in the city of Chicago, Jim Gardner. So my experience started pretty much around May of 2019 with the city of Chicago, and I started to make appeals to the public access counselor probably 6 months after that. And so it's been a wild ride for a retired guy.
Retirement hobby. Well, thank you all for being here and for sharing your expertise. Greg, I'm going to start with you. Earlier this month, there was an article in the Tribune that the paper had sued the city for records being withheld, despite the Attorney General saying that the city had improperly denied your request for those records. I'm wondering, since this is sort of new news in the world of FOIA in the city, I'm wondering if you can start by catching us up on that case and sort of where it stands now in the Tribune's attempts to get those records.
Well, the city denied me some misconduct records in two different cases. One is a broad misconduct around investigations involving the city. One is something specific to the fire department. the city said, no, you can't have them. I've been around long enough that sometimes I'm having the same fight, that I had with the village of Tinley Park in 2014. I'm having it with the city of Chicago in 2022. And so I'm like, no, they're wrong here. I'm going to take it to the PAC. The PAC ruled in my favor. Most of the time, government agencies give it up when the PAC says, okay, you improperly withheld it. Not always, but for the most part, they do give it up. And the city of Chicago has had a few instances where I've beat them with the PAC and they've hemmed and they've hawed, but they gave it up. And in this case, they were just dragging their feet. And, we got our lawyers involved and we said, here's the rulings from the PAC. Give us the records or we're going to sue you. I don't know. I don't want to characterize the city, but they didn't turn over the records. And so we sued them.
Yeah. Have there been any updates? Have they been eager to now run and give you the records?
No. I think it's early in that litigation, but I'm disappointed because I've beaten a lot of governments in PAC appeals, and they don't, whether it's Tony Preckwinkle or the village of Tinley Park or a school district, the Lincoln Way School District. Most of the time, people stop screwing around once they've lost the appeal. And in this case, for whatever reason, the city isn't complying yet.
Well, Pete, that is a nice segue. I know you know a thing or two about that, of people maybe not giving records just because the AG has said so. I'm wondering if you can walk us through the initial FOIA request that you filed with the city clerk's office that eventually led to a binding opinion being issued in July. But initially, what was it that you were asking for?
I was merely asking for copies of parking permit exceptions issued by Alderman Gardner since he took office in May of 2019. The clerk's office came back and they sent me lots of images of pieces of paper with the addresses and license plate numbers appropriately redacted, but the names were also redacted. Now, in my original request of them, I cited the 2012 binding decision that said names are not private information. So I went up and back with the clerk's lawyer a couple of times, and she said, "You're not going to get it. We're not going to give it to you. It's private information. Just go away," and words to that effect. Well, then I appealed to the PAC, and that was during the time of the great upheaval when their website was down for God knows what reason. So I ended up making 50 pieces of paper and certified mail, sent it down there, and they responded. They asked the clerk's office to reply to my FOIA and give them the information, and the clerk's lawyer responded with this really personal attack. The clerk's office argued that Mr. Czosnyka's sole intent in information is for his own personal gains, to leverage his social media blog and continue elevating his Chicago Tribune article, which the moderator wrote, and that I, via some FOIA on my non-existent social media blog, has been known to harass public officials. So I'm looking for names on permit parking exceptions to harass public officials.
So you get a binding opinion, and this is the response when you show them the binding opinion. So what eventually happens? The AG has weighed in and said that you should get these records. What eventually happens with the clerk's office?
So the clerk's office waited till the last 10 minutes when they could give it to me, and they gave it to me. They gave me the names. But the funny thing that happened after that is they sent out letters to each and every person who got a permit parking exception, telling them that their name had been provided via a FOIA request, which I've never heard of before. And I've asked a few other people, and they've never heard that before either. This all ties into, I think, another panel about FOIA and politics, but we'll let that go for a while.
Yeah, I haven't heard of that either. Like people in the public, I know in some agencies, if somebody in the agency is being released via FOIA, I've heard that they are given a heads up from time to time, but I haven't heard about members of the public before. Ryan, you were telling us a little bit about the experience with the school board. I'm wondering how your experience in writing an appeal to the PAC and getting a binding opinion, how it differs from what Pete is talking about. Can you walk us through the scenario with the school board and how you got the PAC involved and what happened as a result?
Yeah, so 9 days after the meeting, I sent an email to the Hillsborough School District, I sent an email to the Illinois Ethics Commission, I think it was, and I didn't hear anything back for a few days, and then I got an email from someone with the PAC, and they said it was addressed to both myself and the superintendent for the school board school district because they could not find the school board president's email address. And then the superintendent basically said in his email response to the PAC and CC'd me like that I had just come down there just to stir the pot, which they're firing a coach who was undefeated last season. So clearly it wasn't just about wins and losses. I needed to figure out why the coach was being fired, talk to some people. And I wanted to hear the people who signed up for these public comments because that would have really given me a good insight whether people thought, well, he got lucky or we really like him. What are you guys doing? Which you see that all the time at school board meetings when someone popular is fired. And I had no idea it would turn into this. So I sent an email 9 days after the meeting, and then they'd opened up the investigation. I didn't get anything back until I think September 21st, which, I didn't know how long this process took. And I was stunned because, I've never done anything like this. I was stunned that it was a binding decision against the school board. I just thought, I didn't really know what to expect.
So you heard back in September. Remind me when the meeting was. What was the amount of time between June
15th,
okay.
And they issued their binding decision in September 21st.
Okay. It's pretty fast.
Yeah, that's what I was thinking too, Greg. What is the sort of timeline that you usually experience between filing an appeal and hearing anything back?
Well, sometimes they can be fast like that when it's something relatively obvious. And, that school district sounds like they were being pretty silly in terms of, the public comment is the public comment, for God's sake. It's got the word public in the name, it's like, let's use some common sense every once in a while. I will say I was feeling a little jealous, and I don't want to off track us, but with Ryan and Pete getting criticized, I'll do you one better. I once had a school district brought me in to have me read their documents, and they played a country song called Kiss My Country Ass at me, while I was sitting there reading the documents. So that was kind of fun.
Like on loop, is this just over again? It's now burned into your brain. Wow, that is clever.
It was not bad. But no, it's just kind of entertaining.
It absolutely is. There are stories for days when FOIA is involved. I'm wondering if we can get sort of into the nuts and bolts of the appeals process. Greg, I'm wondering if you can weigh in on filing an appeal with the PAC. Your appeals last year resulted in 3 of the 12, so a quarter of the binding opinions that were issued last year from the PAC's office. How often do you file with an AG? Are you filing as soon as you get a denial from the agency, or what is kind of your approach to bringing the PAC in?
So despite I have 3 appeals that were binding and a bunch of others that were non-binding, and I file a lot of FOIAs. I don't like, and I'll beat them up on Twitter too if they're doing something I think is improper. I don't really want to beat up on the city. I want the city to comply with the law and to be communicating, but they don't always do that, and they don't always follow the law. And so what I found is I have to I regularly file there's two categories really. There's the routine ones where I'm just like, let's just double check with the state that you did this properly. So really that applies to emails and to text messages. Like Lori Lightfoot's emails and her text messages are great examples because they'll give me 300 pages of the mayor's emails, and a bunch of them, some will be redacted, and I want to be sure that they're not redacting something goofy. And here's a great example where there was an email from a guy who was her senior advisor on labor stuff, and the subject line was "our agreement," and they redacted the whole email. Now, an agreement is final. You know, an agreement is not preliminary. It can't be preliminary by definition. An agreement is an agreement, right? It's not it's final. We have agreed. Now we're working on agreeing. So I'm like, what is this? And I asked for it, and they had redacted. They had fully redacted an email where one of her aides said that they were betting on the teacher strike and how long the teacher strike would last. And he said, the mayor has it longer than 2 weeks. I have it at whatever. And the chief of staff has it at whatever. And we're betting 3 cigars and a scotch is what the bet was. And, you know, that's not, they had redacted it on the basis that it was policymaking. And that's not policymaking. That's just a dumb email that a guy sent, you know, like, and it's embarrassing. It looks bad. And so they redacted it. Another decent example is the mayor once ripped up a memo that she had sent her, that her staff had sent her. And she said, I want more than 48 hours before I look at a memo. And if you try to give me that, this is what I'm going to do to them. And so she sends them the picture of the memo. And I'm not even paraphrasing. I mean, that's what she said. And they had redacted that as policymaking. And in both those instances, the PAC said, no, that's not policymaking. You know, you have to release them. So no matter what, I ask for, I go through the emails with redactions and I say, please check those, because then they have to give, the city has to give the PAC the unredacted versions, and the PAC decides whether or not they're real. I will say that I think the city behaves a little better. There have been less goofy stuff. Like there have been releases that have stuff that's embarrassing, you know, that they didn't try to hide. And I think that's a result of the appeals that we've won. But so there's that. And then there's philosophical things where they're just not giving anything. And I think you should almost always challenge when they're withholding everything. They're almost always going to be in the wrong, because the law is also meant to be narrow and pinpoint redactions. It says it in the ordinance, in the statute. So I try to redact everything, both because you want to make sure that they're behaving well, you know, because I would assume, and I am in assumption mode here, but with the ripped up memo, I would assume they thought we're going to redact it and he'll never know, you know, because he's not going to appeal it or challenge it. And I certainly didn't think that that's what was going to be underneath the black ink, you know, like just like with the bet, you know, if I was speculating, I thought that it was probably a proper thing about, you know, we agree we're not going to cave in on the CTU or something is what I thought, you know, something like that. I didn't expect that it was about a bet. So you should almost always be appealing denials, if only to keep them honest.
Yeah. Pete, I'm wondering about you. I know you also file a lot of FOIAs with a lot of different city agencies. How often are you bringing the PAC in? Do you have a similar strategy that you are appealing almost every time you have a denial? Oh, I think Pete maybe.
Departments.
Oh, there you go.
Okay, so from two
Pete, you were frozen
particular.
for a second.
Okay, so I do a lot with the city, and from 2 particular city departments, they've ignored the 5-day limit. They've just blown off the 5-day extension. I've sent a tickler and they ignore that. And so I appeal to the PAC, and 5 times now, 4 hours after I appeal to the PAC, I get the information from the city departments. So you've got to think that this is some kind of willful and malicious action on those 2 departments.
But when you're bringing in the PAC, you have pretty good luck with getting things.
Yeah, so I get stuff. So that's, you know, a win. That's a small win as far as the title of this panel goes. That's a small win. And also if I get some kind of, you know, decision from to agree with it, obviously I sent it in If they agree with the city department, that's still a win. They answered it, so I like that. But that binding decision, that was only my, like fifth or sixth appeal to the PAC, and that was a binding decision. And I really think that, there's a whole different categories of binding decisions, right? So if FOIA law changes, if a new law comes online that affects FOIA somehow, they have to make a new binding decision. If you get some wacky claim from a city department, I was part of a binding decision with the Northwest Side Coalition Against Racism and Hate, and the village of Morton Grove didn't want to provide their police vacation schedule on Insurrection Day, citing national security. So crazy. I mean, why would a past police history of records of attendance be national security? So that came back as a binding decision. So that was a good taste in my mouth. This one about the names, the PAC said, well, they clarified some things from the 2012 binding decision that I had cited originally. And they used that to along with, specific. I mean, names, I guess, can be a very fact-specific kind of a thing, whether the Reese those or not. And so since it was of general interest to see what the alderman was doing, who he was granting favors to, it was of general interest, and they made this binding decision, I would imagine, to update things. And the other one is like they always have to provide reminders from the PAC. How many of the duty to respond to FOIA requests binding decisions are? There must be 20 of them over 20 years. I mean, they're doing that endlessly. And so that's another, but like on Greg's one from last year about the duty of the public body to offer to confer, I just at lunchtime. And in the panel I was in, listened to previously, they refer. I mean, that makes a difference. It makes it easy for somebody to use it, and it moves things forward.
Which is interesting. I was going to bring up that binding opinion from last year that, Greg, you were involved in as well. I mean, it's interesting because they're basically, what the PAC is doing there is basically telling CPD to follow the law as it was written. So it's not a binding opinion that's like, really changing things. It's more just like reminding an agency to comply with the law as it already is written.
Yeah, and that, just to recap for the viewers, I have a FOIA that I file every month with a whole bunch of government agencies for any grand jury subpoenas they received over the last month. And the point is just, if the FBI, the mayor's office generally does not get any grand jury subpoenas, right? So if a grand jury subpoena comes in, it's going to be of interest. And CPD routinely gets grand jury subpoenas because it's just part of their workload. It's how you get them to, the state's attorney has to formally subpoena officers to come testify. So they get a ton of them. That's fair. And this, I told them I'm only looking for federal grand jury subpoenas just in case there's anything coming. And they said, we can't possibly search. We have 3,791 or whatever number it was. And we can't go through all those subpoenas to see if any of them are relevant. And I said, well, how do you track them? Let's discuss how you track your subpoenas. Do you really just put them in a manila envelope? I would guess that you guys probably track them in a spreadsheet somewhere, and you can figure out very quickly how many, if you had any federal grand jury subpoenas, and they were told, yeah, you have to do this search, and you can't hide behind it, and you can't refuse to engage, because they refuse to talk to us too, which is one of those things where I kept saying, let's talk about it. And then a few days after the PAC came back and said, we're going to look into this, I think that the labor lawyer, after like a month, had finally responded to me for the city. And I'm like, well, FYI, I hope you saw this PAC interest in this. And she said, oh, okay, well, now I'm not going to talk to you. Now it's going to go through the PAC. And it's just, people are busy, but there's a real stunning lack of professionalism sometimes from a lot of these agencies when it comes to FOIA, and it's good when the PAC comes in and lets them know.
Yeah, Ryan, I wanted to bring you back in here. We've talked about interactions with the PAC, and I know this had been one of your first ones at the school board meeting. And I'm wondering if you have now had reason to go back to the PAC, or if you have been back at similar school board meetings and seen behavior different after that binding opinion.
No, I actually haven't been to another school board meeting since then. I haven't run across anything that has caught my attention, and you know, I have to say, and it's probably been mentioned in other FOIA seminars here. You know, the problem with the elimination of so many journalism jobs is there's so many fewer watchdogs out there. So when you have a citizen watchdog like Pete, it's helpful because someone's not every government body is out there trying to, you know, hide behind things, but you've got to have someone who is watching all these government bodies. And newspapers used to have people at county water board meetings and, you know, park district meetings, and now we're lucky to get to, you know, a school board meeting for our biggest city in our coverage area, which is Springfield, and the Springfield City Council. And you know, there could be things at all these school boards or county boards or city councils that are never caught. And you know, that's the disappointing part about, you know, the lack of all these journalism jobs.
Yeah, I know that's something that you had said to me, Ryan, that like you happened to be there that night because it was a story of interest, but had you not, this probably would have gone unchecked.
There was a weekly newspaper reporter there. He's also the publisher for the local community. Mm-hmm. And I don't believe his newspaper ever wrote about it, even after the binding decision was announced. I mean, you know, these things, you know, in small towns, I mean, sometimes those aren't the best people to have watching your government.
Yeah, it's interesting. Anyone can jump in here, but I'm wondering, we've talked a little bit about the timeline of hearing back after you file an appeal. I know that sometimes it can feel like your appeal goes into this like never ending queue of appeals. So I'm wondering if anybody has any sort of strategies in hearing back and how to sort of converse with the PAC's office after you send off the appeal.
I'll start on that, and I would just encourage people in general in life and with the PAC, the squeaky wheel gets the grease. You know, you want to make sure that people know you're there. You haven't forgotten. You didn't file a request for review, you know, in like a frenzy, and then you forgot about it. You know, you also want to be respectful because they have a lot on their plates. In fairness to the PAC, you know, they have a lot of requests, but in general, hey, check in with the person handling the case and just send them a note and say, hey, you know, I'm just curious, what's the status on this? Every couple weeks, every few weeks. And, you know, it just reminds them, hey, somebody cares about this as well. And it's not just, and, you know, but that's true in life and in everything that you care about or want to pay attention to is you want to check in.
Yeah, and true with filing Foia'S too, right? True with getting information initially.
I like to say very often that as reporters, a lot of our job is to be debt collectors. It's to ask people, hey, you know, where's the bill? Where's the check? You know, and sometimes they try to tell you the check is in the mail, and you got to remind them that we live in the time of direct deposits. So let's get a move on, you know.
Greg, maybe the better strategy is going to the wrong office to file your complaint. Maybe you'll get a response faster.
I am curious. I would be curious in hearing from any and all of you why it is that you think that binding opinions are so rare. As we've been talking about, there were just 12 binding opinions last year, and why you think that is, and if you think it would be better if the PAC issued more binding opinions. And actually, I'm sorry, if we can wait 1 second, if we can back up from that question. We had a question from the audience, somebody asking the difference between binding opinions and non-binding opinions. So I don't know if somebody wants to jump in and start there.
Well, I would just, on that, you know, under a binding opinion, they have to obey it, or else they have to file a lawsuit against you and the attorney general saying that they got it wrong. So, they don't have to obey it, but unless they have to obey it unless they sue to challenge it, and then it becomes a court battle. A binding opinion is not binding. It's not. They don't have to obey it. They can just ignore it. In general, the PAC's office doesn't like that. So if they're ignoring it, then you just file the same request, and then they'll consider doing a binding opinion. But most places treat a non-binding opinion as though it's binding. It's not. But that's the most places see it and they're like, yeah, that's the end of the line.
So, Greg, why do you think that binding opinions are so rare?
I think the PAC is overworked, and so they're trying to be careful. They're trying to manage their time. I think there's more review for a binding opinion, and they want to make sure everybody's on board. There's probably significantly more research. And I think they want to focus on stuff that isn't clear or that is novel. So something like, if the mayor is texting on her personal phone instead of the one that the city gave her, is that exempt from FOIA somehow? And the answer is no. It doesn't matter. It's just, is she doing public business on that phone? What phone she uses doesn't matter. But I think, and I've asked PAC people about this. They're generally looking for something that can really make a difference because it needs clarification. It's a little fuzzy. It's newer, and so I would love to see more binding opinions. But I understand what they do.
Can I ask a question?
Please.
So if they've issued 12 binding decisions, how many requests for reviews do they get in a typical year? Does anybody know that?
Yeah, it's interesting. I don't off the top of my head. I mean, hundreds.
It's certainly hundreds, and it may well be thousands. I think it is thousands. I mean,
I would think so too.
They are flooded.
And
you should be able to go to the binding opinion page and just look at the numbers. They put a discrete each binding opinion, and it's got to be like when that came in, that signed not only to the binding opinions but to the decisional letters also. And so just look at the last binding opinion of the year and the first binding opinion of the year, and you'll get a ballpark of how many appeals that they've had.
And they checked in with me a couple times throughout the process. They would get a response from Hillsborough, and then they would come back and ask me if I had, a response. And, I think both times I said everything that I had was in my email to you. The only thing I did ask for was, I said, if you could get a copy of the public access card, or the public comments card that were available for the public to fill out, I would like to see that. They got it. I don't think I was allowed to see the copy of it, but they did say that they ended up getting a copy, and it definitely said on the public comment card that they were public comments.
Right.
And they took each person that signed one of those back in closed session one by one to listen to the public comments. So
is that where that ended, Ryan? Was that the end of your interaction with the PAC on that binding opinion?
Yeah. I mean, I didn't get a request for, like Greg said, an appeal. I think they have 30 days or 35 days to file an appeal. And when I saw that, I was kind of like worried, just a little bit, like, because I've never been named in something like that. So, but I didn't think they had a leg to stand on. But then again, I'm not a lawyer, so.
Yeah.
I just looked at the PAC's page, and there were about 3,000 requests last year and 12 binding decisions.
Wow.
Yeah. So Greg is in the camp of more binding opinions. Pete, is that something that you would like to see from the AG's office as well?
If I get an answer and the department follows through, I don't care if it's binding or not. A binding decision is kind of like a nice feather in your cap, and that's congratulations to both of these guys for having binding decisions, and Greg for having 3 last year. That was remarkable. I can clearly remember reading 21001 early last year, and saying, This tells a story. I mean, there's the whole kind of way how it goes, and the paragraph that he said they're just trying to put me in a trick bag by saying I had to do this, and then they refused. It's a nice, clear nutshell. You have to summarize what you think the department is doing to you or doing that's against the law, and kind of summarize it quickly, and then let the PAC go through all the dates and informations and footnotes and laws and things.
Yeah, if I could just on that point, I would encourage anybody watching who files a request for review, you do want to tell a story as much as possible. Now, different people have different styles, different levels of interest in the law or the finer points, but you always just want to. And this is true for storytelling as well. You don't want to speak in 7 commas. You want to speak in simple declarative sentences that people understand what the hell you're talking about. And you always want to make sure that the just tell the PAC, they did this, they did this, they did this. It was bad because of blah, blah, blah. And I always try to go for that. I get a little snarky with my request for review sometimes. I once included the village of Midlothian was refusing to give me a police officer's photo. He had just been indicted, or he had just been investigated for police misconduct by the feds. So I asked for his employment photo. They said that it would reveal his biometric information, and that a photo of a person is private because it's biometric information, which is total crap. And I posted a picture to the request for review of a classroom with students and a cop and a little stuffed lion that was all in this picture that was on the Midlothian website. And I said, if that is true, they're violating the law here for these 7, 8, whatever children and the lion. And I won that case pretty quickly too.
You told the story. I was going to ask if you all have sort of like a form letter that when you are sending a request for appeal, but it sounds like, Greg, you start from scratch every time.
No, I have unlike one of the most overused exemptions is unwarranted invasion of personal privacy, which is a balancing test. So I have standard language that goes to that, which I'd be happy to share with anybody wants, but the basic language is, the government will always say, oh, it's an unwarranted invasion of personal privacy. And I always say, well, they're leaving out the part that says that it can't be an unwarranted invasion if it involves their public duties. And I'm not asking about Joe Schmo's child or their love life. I'm asking about Joe Schmo's emails about, I'm asking about Joe Schmo's discipline for whatever it is he did. And, he was disciplined at work for something that involved his work duties. That's not a personal invasion of privacy. And so that language is always there. There's different language that I reuse, but so it'll start at the top with the unique facts. And then there's language I use. And, Pete, you're another guy who files a lot. Do you have standard language?
No, but I try to follow a standard format. Try to lay it out just the way a binding decision would be laid out. So in advance of that one from last year, I read a bunch from previous years and see how they were laid out. I try to name the attached files similarly. So if it's an email from me to the department, so it's EM underbar, my initials, what the topic is, underbar, what the date is, and follow that through to make it as easy as possible to kind of pick out these things so people aren't just going crazy. I remember when I first started, I put off record keeping for like a month, and I wanted to tear whatever little hair I had out. So it becomes really difficult if you don't keep track of your records pretty religiously. So no, it's not, just as long as the format is there, try and get that nugget of a little story somewhere towards the end, like Greg does, and that is enough for me.
Yeah, I'm curious to hear from each of you what impact you think binding opinions have on future FOIA filers. I know that Pete has cited a 2012 binding opinion, so this is things that different folks use, but I'm curious to hear, maybe specifically the binding opinion you were involved in, how you hope that it will help folks who are filing FOIAs in the future.
Well, I like to think that will help other just regular folks like me do FOIAs. Like I said in the article that you wrote, Courtney, if everybody was doing this, government would be a lot more responsive. I think the various departments are a lot more responsive to me because they know I'm just not a one and done kind of a guy, and nobody uses my last name anymore. Every letter I get is just Pete. Even the titles of the files that they send is just Pete. My last name doesn't matter. They know who that is. So people in the neighborhood who have asked for advice, the other binding decision I was involved in, because they asked advice and I offered the response to the Village of Morton Grove lawyer, and I did, and we got that binding decision. So that was number 5 last year. So that was pretty fun. And more people do this. I get other people asking me to make FOIAs for them. So, fills out my day.
Your retirement hobby is paying off for you, Pete. Ryan, I'm curious about you. What is your sort of hope for your binding opinion that you were involved in last year? What is the impact?
So in 2021, I believe that there were 3 violations of the Open Meetings Act in the downstate area: Bloomington, Decatur, and then Hillsborough. Hillsborough was the one I was involved in. And, I don't think that the governments are necessarily doing it to be, I think most of the time it's an honest, they don't know the rules. I mean, you run for a school board, you get on the seat, but you don't read the Robert's Rules of Order, or you don't understand everything that goes on with it. And yes, you should, but I think it's just sometimes out of ignorance and the violations occur. So I hope that when the Bloomington School Board District is found to have violated the Open Meetings Act, and the Hills, and all within a year span, maybe some more school districts will take a look, and maybe their lawyers will say, hey, look, guys, I mean, we've got to have maybe a training on this. We've got to go over this stuff again because there's been too many of these violations that have been found out.
Yeah, and I know that's part of what the PAC does as well, that they will train agencies on compliance on both FOIA and open meetings. Greg, I don't know, do you have anything to add on the impact you hope that your binding opinions have?
I'm glad to set some good precedents, that I think that hopefully will help people. We have we have an information law that's not just for journalists, it's also for citizens, as Pete demonstrates. It's also for actually companies use it. All sorts of people use it for all sorts of reasons. And that's a beautiful thing because the more information is out there, the better. And I think that sometimes maliciously, sometimes innocently, sometimes incompetently, those are probably the three main categories. People will mess with people's right to know, and hopefully the binding opinions help.
Yeah, we have a question from an audience member, Michelle, and other audience members, feel free to put in the Q&A. We would love to have your questions. Michelle is wondering what authority you wish the AG's office had.
I wish they could find people. I wish that either they or they either with a petition to find them or something. I wish that there was a bigger punishment for governments abusing FOIA. They do have to pay your legal fees if you end up suing them, so that's good. It's not helpful at the PAC level, but it's good there. But there should be consequences for serially disobeying the law, and I'm not talking about the first time, but I am talking about several times or when there's a lot of problems. But it would be great if If there was a way, if there was another bit of consequence, like I remember, I actually think I don't think that they can just they don't like the law should also be clear that if they don't respond within a certain period of time, that they should have no ability to object whatsoever. They can't object on the unduly burdensome basis if they don't respond within the time frame. But they shouldn't be able. They should lose by default if they don't respond. Like for instance, I was going back and forth with the city on an appeal, and so I file an appeal. They have whatever it is, 10 days to respond, and the city wasn't responding for like 30, 40, 50 days, and I would respond and say, tell them that they need to respond within the next couple of days or else they're going to lose by default. And I don't think the PAC really has that authority. But, the PAC was like, please respond. But I'd like to see more consequences.
Yeah, I wish it had. I wish the PAC had teeth, because I think that the fear of financial repercussion would help incentivize government bodies to know the law, understand the law, and maybe dissuade them from committing violations.
But we've seen public bodies paying hundreds of thousands of dollars for lawyers when they lose FOIA cases, right? That's what Matt Topic and all the guys there are busy involved in. When they win, their legal fees. That's a huge incentive, but you have to go to court to make it happen. So you're not going to go to court for these small things like I get where they ignore me and then I appeal to the PAC and 3 hours later I get the information I wanted. But for the bigger ones, the meaningful ones, that is a pretty substantial kind of a penalty.
Yeah, that's a good point. A question in the chat from Brady. He is wanting to be clear on something that you said earlier, Greg. When reviewing the legality of the redactions, is the PAC allowed to see everything that has been redacted? Are they able to see everything that the agency redacted?
I'm 99% sure the answer is yes. The PAC says, give us the unredacted versions and we won't be giving it to Mr. Pratt unless there's a ruling and we'll order you to give it to him, but we're not giving it up to him. I once had the city tell the PAC that they weren't going to give them the unredacted version, and the PAC was like, cut it out, give me the unredacted version. How can I rule? Because they can't really rule if the redaction is appropriate or not without seeing what's underneath the black ink. And so I believe that they are categorically allowed to see behind the redactions at issue in an appeal. And I don't believe, but every once in a while you get some goofiness.
Yeah, well, we just have a few minutes left, so I want to open it up if any of the speakers have questions for each other, or if there's anything else that I didn't get to that you would like to touch on, feel free as well.
What do we want? What I'd like to see is, in a city that has multiple forces, it's like they play a shell game. We'll put this bunch of information under this department that makes no sense that it's there. And then when you ask the department like OEMC or somebody, they say, oh, that's not us. Go find the right department. And you're on this endless search. I'd like to see in a city that's got multiple FOIA departments like city does, that the FOIA office that you ask has to refer you to the correct FOIA office instead of just hiding it somewhere.
It is your FOIA dream scenario.
I wish that every FOIA officer took it seriously, but plenty do. There was a FOIA officer who was connected to the Burkes politically, and I filed a FOIA with the sheriff's office looking for information about Ed Burke Jr. He had been fired from the sheriff's office. He had done a bunch of goofy stuff. I've written about this and published it. And the FOIA officer gave me the full reports, even though they had some connections to Burke and to that family. You know, they didn't screw around on it. They were on time. They were professional. They turned it over. There are FOIA officers that I could have really, really good conversations with about the law and why they disagree with me and why they don't. And, you know, there are FOIA officers that and that's valuable because, of course, sometimes we're going to disagree for real. And then there are FOIA officers who, you know, it's like trying to have a conversation with somebody in the movie Idiocracy, and you're trying to explain to them why you need the water to plants and you can't give it the Brondo, you know, and then you explain that it needs H2O, and they say, yeah, but Brondo's got what plants crave. And you're like, good Lord, you know. Every once in a while, my point is there are a lot of really good FOIA officers, including at the city of Chicago. There are some bad ones, including at the city of Chicago. And the problem with that, though, culturally, is I don't think any government agency says we're gonna put a priority on this for real. You know, every politician campaigns on a transparency thing, and then they realize we're the gatekeepers to embarrassing information that we're gonna get asked a bunch of questions about, and so, you know, it falls by the wayside. But it would really be great if people took it seriously.
So it's been let in, is what you're saying, Greg.
I think that the light is flickering sometimes.
We are over on time. Michelle asked if the AG has subpoena powers, and I'm not sure. Does anybody know on that?
I don't think it's subpoena powers per se, but they do have. They can say give us the stuff, and whether or not somebody decided to be cute and fight it and how hard. I don't know that anyone has tested that in too crazy a way. Yeah. Maybe some FOIA officers watching this and is going to get the idea.
Well, thank you all for this great conversation and for all of the great work that you all do.
Thank you for inviting me.
Thank you.
All right. Bye, all. Thanks for being here.